FORA.tv. The world is thinking.
Well, in many ways, the institutions that enforce constitutional protections suffer from a similar disconnect, an inability to recognize what history has shown us about our failure. And the administration of the death penalty is a really perfect example of this phenomena. In the United States, we are struggling with capital punishment and its implementation. A short, quick legal history. In 1972, the United States Supreme Court struck down the death penalty after recognizing that it was being applied in an arbitrary manner. The court in 72 noted that 87% of the people executed for the crime of rape were black men convicted of raping white women. 100% of the people executed in the United States between 1930 and 1972 for the crime of rape were executed for offenses involving victims who were white, even though it was believed that women of color were 3 times as likely to be the victims of sexual assault. The court didn't say that the death penalty was cruel and unusual punishment and therefore always unconstitutional. They said it was arbitrary, unpredictable, capricious, and therefore unconstitutional. A lot of folks thought that was going to be the end of capital punishment in this country, but as most of you know, states passed new death penalty statutes that were aimed to control these arbitrary features, and by 1976, we had a modern death penalty on the books. It's the modern death penalty that has now produced some 3,500 people awaiting execution, some 1,100 executions in the last 30 years. Well, interestingly, this question about race and the death penalty continued. Lawyers from the NAACP Legal Defense Fund went back to the Supreme Court in 1976 and said the modern death penalty is going to operate no better than the old death penalty. We're still going to see disparities based on race. We cannot expect in American society that the problems of race bias, race consciousness, in the early stages of a post-apartheid era are going to be eliminated with something this insignificant. We're going to continue to see race bias. And the court said no. We said, no, we're not going to respond to that argument until you can prove to us that the American death penalty is operating in a racially biased manner. And that gave rise to a third case, a case called McCluskey versus Kemp. I talk about it a lot, even when I'm talking to non-attorneys, because I think it says something very powerful about this crisis, about this inability to connect ourselves in a broader historical way, and how it results then in a sort of a deepening of a divide that I think is fracturing American society. Lawyers went back to Georgia and they said, well, okay, the court needs some proof, the court needs some evidence, and they did a very sophisticated study. David Baldus, a researcher out of the University of Iowa, led a team of researchers who looked at every homicide in Georgia over an 8-year time period and came up with some very powerful data about race and the death penalty in Georgia. This 8-year study established that in Georgia, you're 11 times more likely to get the death penalty if the victim is white than if the victim is black. If the defendant is black and the victim is white, you're 22 times more likely to get the death penalty. Now, these disparities were subjected to all kinds of multivariate analyses, and econometric tools were employed to somehow explain away the race effect, but no matter what combination of variables, even the state of Georgia proposed, race was the greatest predictor of who got the death penalty. Well, armed with these data, the lawyers went back to the United States Supreme Court in 1987 and said, here is your proof. You said you needed proof, here it is. We've got data, we've got the most sophisticated study of the criminal justice system in the 20th century. We have all of these facts, all of these studies, all of these variables, and they all point to racial bias and discrimination. And interestingly, the United States Supreme Court didn't say, we don't believe you. They didn't say, we doubt these data. They accepted the evidence as true, and nonetheless held in a 5-4 decision that Georgia's death penalty is constitutional. Now, I have to tell you a little bit about this case. The court said 2 things to support its judgment. The first thing the court said was, if we recognize disparities based on race in the administration of the death penalty, it's going to be just a matter of time before lawyers start complaining about race disparities for other kinds of criminal offenses. They'll point out disparities based on race for drug crimes and sex crimes and misdemeanors and property crimes. Justice Brennan, in his dissent, ridiculed the court's analysis as, quote, a fear of too much justice. And in a lot of ways, he was right. What the court was saying is this problem is too big. The second thing the court said, though, was, for me, the more significant thing. The second thing the court said was a certain quantum of bias, a certain amount of discrimination is, in our opinion, inevitable in the administration of the death penalty. Inevitable. Now, I'll tell you that in my 20-some years of representing people on death row, nothing has been as difficult for me as reading that decision. Nothing.